should deputy speakers vote? Justice Abdullahi took the matter to the apex court, and the Supreme Court delivered its ruling, a unanimous decision saying that, yes, on the back of the law, the spirit and the letter of the law, these members of parliament who eventually serve as speakers are members of parliament. They represent constituencies. Honorable Esiama represents Fomena constituency. Joe Sewusu represents Bekwai. Why prevent them? And so the Supreme Court has said that they should vote. What's your take on that?
I think that the Supreme Court is wrong. Because, well, that's what I'm going to say. You know, the Constitution tries to make a delicate balance between three competing values. One, the right of representation. But at the onset, the Constitution creates certain limitations on this right of representation. For example, in the conflict of interest situation, you're not supposed to, no member of parliament is supposed to sit on an issue that involves him. So conflict of interest is a limitation on the right of representation. Right. Then the Constitution also prevents the crossing of the carpet. You can't cross the carpet. It used to happen in the past. And the Constitution that we have now is intended to stop that business of people crossing the carpet, from time to time. And then we must not forget one thing, which is very important: the right of the MP to abstain. That is very crucial because that affects the issue of the standing order, which says if you are a deputy speaker, you cannot vote. Because you see, if you take the individual MP, an issue will come to Parliament, then he can say, I'm abstaining. I'm not voting on it.
Right.
Now, so nobody is suggesting that that is unconstitutional. So that position is intra-virus. It's within the law.
Not ultra-virus.
It's not ultra-virus. Now, the standing order, which says we collectively decide that when you are a deputy speaker, you must not vote. How can that be ultra-virus? If the individual can take that position and it is intra-virus, but the collective, in their power to regulate the proceedings of Parliament, they have that absolute power. They say that, look, we are deciding collectively that if you are a deputy speaker, you don't have the vote. How can that be ultra-virus? I don't understand.
You're quoting the Supreme Court when they say that upon a true and proper interpretation of Articles 102 and 1041 of the Constitution 1992, a Deputy Speaker of Parliament or any other member of Parliament presiding over Parliament is entitled to be counted as part of 1/2 of all members of Parliament present. That is to say that a presiding Deputy Speaker is entitled to be counted for the purposes of forming quorum. And they go on to talk about voting rights and that he or she is entitled as well to vote. You feel they got it fundamentally wrong?
Yes. How did they come to that meaning of the Constitution?
But the apex court, when these matters come to it,
yes, I know
they have the interpretive role, and that's exactly what.
But they have interpretive the role to interpret, but it does not give them the power for judicial legislation. You see,
which is what? How do you?
Which is, look, if you give a decision which is per incuriam, just because you have the power to interpret, then of course you are creating judicial legislation. The court has become like a legislator. Now, the point is that when they made the standing order, everybody has been supporting that standing order. And that standing order really, as I say, is a collective decision that if you are a deputy speaker, you don't vote.
But is it not because we've not had this peculiar situation in which we find ourselves with a hung parliament?
Yeah.
It's a very different parliament.
But you need to.
So we would need a new set of rules.
But how? Well, is that for parliament? Is that for the court to give those set of rules? No, it's not for the court. Now, how did the court come to the conclusion that the Constitution means what they say it means? How? I would have liked to see very learned discourse on the intentions of the Consultative Assembly. Look, if it had been like the United States or Britain or other places, you would seek the interpretation of the document from the proceedings that brought that document about. And it's an elementary principle of interpretation of statutes, that you look at the proceedings surrounding the provision to see what sense the makers of the Constitution or the statute intended, and particularly with regard to
what the Supreme Court suggests it did.
Did they refer to any provisions of any proceedings of the Consultative Assembly? They didn't. They just thought it was irrelevant, and it seems like they had forgotten the elementary principles of interpretation that every law student learns when he goes to law school. And particularly when you are dealing with a fundamental document like a constitution, you interpret it widely to make sure that you give effect to what the makers of the constitution want to achieve. You don't restrict it. You don't do a restrictive interpretation. I mean, the rules of interpretation are there. Which one of them referred to the proceedings of the Consultative Assembly?